But I think somewhere in the bill, the right of appeal by the individual can be there, and this is one of the things they could go to a court to seek information from if the review panel don't think it's appropriate to give them. But I don't want this change, because the due diligence for firearms is quite extensive and intensive, and it's not all information you necessarily want to give to the individual. Remember, it is not a matter that a lot of the information on that evidence or material, and therefore I'd prefer it be remain, and if the person feels duly wronged, the court system can be used.
Chairman, if I may comment on that point. Yeah. One of the difficulties I have with that, you said, then they can appeal it and then they can go to the court. Yeah. In this instance and other instance.
Yeah.
To seek redress through the courts is not like walking down the street to buy a patty.
Know that. That's why I put them to the court.
No, it costs a lot too.
Yes.
It costs a lot.
Yeah, well,
and I just want us to be mindful, Chairman, that we must make exceptional efforts to make sure that by virtue of the legislation we put in place, we don't impose those burdens, those hurdles on an innocent or possibly innocent person. So that's my general comment in that.
Yeah, and
I do appreciate, right, what we want to achieve. You want to sieve out, we, all of us, want to sieve out those characters who are not to be in possession of a firearm, to hold one. There's a shared commitment to that. But I don't want in our exuberance to achieve that we make innocent persons victims and impose the burden, financial and otherwise, on them. That said, in that same section, I just want to highlight D3C, and it reads, domestic violence or who is charged with an offense. A charging of someone is like an allegation. They have not been proven to be guilty of it. I would rather word it like they are convicted. Then that would disqualify them. But mere charge, we know many cases go to court and after being charged, you don't go anywhere because it can't stand up. Now again, you're denying someone of a possible privilege, benefit, whatever we want to call it, on mere allegation. So I would like for us to give some thought to the wording, charge, and as I suggest, if we consider substituting that for being convicted.
No, I hear you loud and clear, member, but I think I'm the one, in fact, who have emphasized the separation of the illegal prohibited weapon from the legal side. The legal pistol is still a killing machine, period. And I don't want to see that we are treating it in a lighter way. The information on domestic violence, which is an indication of an individual emotion, well, as I say, personality, behavior, is not one which is a conviction. If there's a report, it has to be checked. If it doesn't play out, then they can appeal at the review panel and it is dealt with. Any report of any individual displaying elements of domestic violence must be refused a license. I don't need a charge. I don't need a conviction. Once he is reported to have abused, whether his wife, his girlfriend, or his child, and there is reasonable information and a report, then he's denied. And the issue of domestic violence is still a very brutal activity, and although it is only 25% of the total homicide, it is something that must be, a strong message must be sent. Now, there are people playing games, they report and they don't pursue, and that kind of activity. But that's for the individuals involved to deal with that in the relationship. We cannot take a chance in this. And I would not accept a diluting of this. Once the report is made, the authority must take it seriously. Not going beyond that. That somebody is lying, yes, it can happen. But the report is made, there's no right to bear arms in Jamaican society. And you cannot have any alleged domestic abuse or trafficker being allowed to hold a firearm for a day. The recourse to come back is fine, but that I can't do. The other, to be, I said, I know going to court is...
May I make a comment, Minister?
All right, I just complete my comments. 4, court is expensive, but the mischief of correcting an issue. Again, the steps being taken to ensure we have a highly credible board and review panel will correct most of the mischief. What you're trying to correct is the one who slips through. He's not a shutter. He's an organizer. He's establishing good business in the community. He may be a very good nominal and in brackets attender of church, everything being charitable. And he has the money and the image. But we know from other information that he's not right. Let him go to court and pay his money. And when he goes to court, the information will be made available from that point of view. The exception is the concept of a nice, innocent fellow losing his license. It's rare. It's rare. It is the man who slips through the ring. And that's what the legitimate side must seek to protect the Jamaican society from these people who are operating illegally, but with a manufactured image that creates a problem. And they have money. They are paying money for the license. That's what we are discussing the other side, what you've done today. When you hear reports of many of them, enough information here to confirm people are paying $500,000 to influence people to give them firearm license. Let them pay $1 million go to give a lawyer. Quite confident that I'm not being biased towards either lawyers here, but that makes a lot of it. They are prepared to buy a license for that. We'll stop the buying, and therefore they go to court and pay the lawyers the money. They are professionals entitled to seek justice, and if they are paid for their services, that's fine. Investigators carry out the activity based on the intelligence and information that's available, and not all of it will be public. Sorry, Senator Scott.
Minister, it's complicated. It's complicated. A lot of us who practice in the criminal courts understand how complicated it can be when an allegation is made. But as I listen to you, I recall that in both Barbados and Trinidad, one of the things that an applicant is required to do is to submit a psychometric test. And I'm wondering if it wouldn't be helpful. Psychometric. A psychometric test.
That's it, that's additional.
Which captures your personality completely. And it would be an independent safeguard in the granting of a license. I wonder if the policymakers would not consider that is one way in which people who ought not to hold a firearm could be weeded out at the start.
I'd ask my minister who would want to come in before, so Minister, and we want to comment on the issue, but a psychometric test is not much different from an allegation. You know? I must confess, I've had a lot of experience with them now as they employ individuals. It now become almost routine in the public sector, I think, either for promotion or appointment, to do psychometric tests. And, but it could be a valuable additional tool. I must tell you, I'm not going to argue that. Minister?
Chairman, in support of my colleague's suggestion earlier, is an important point that we must all be reminded of, and is that guns don't kill people, you know. It's people who kill people. And if we can have a good idea of the nature of the individual, I believe something like this should have been in place decades ago. So for us to be proposing it here and even hemming and hawing is, to me, a non-starter. We need to have something like this in place. And personally interviewing somebody at FLA cannot tell you what type of person this individual is, even except for the answers provided at the time. So I don't believe that this is something that we must just sweep on the carpet. I support the suggestion wholeheartedly, and I think moving forward, this is where we need to be.
No, I'm not sweeping on the carpet. It's once we consider, and I'm quite serious. I've had experience with it more from where I sit, because it's something that is maybe practiced more widely in the Ministry of National Security and other ministries. You know, for appointments and promotion, psychometric test is a standard operation now, by that. So I've had, whether 40 or 40, quite a large number of them. And while I think they are of value, I'm not going to put the level of I don't think it's something that has the empirical, has had enough for the kind of empirical credibility you're giving to it, but it is of value as a part of a personality evaluation. But it's the kind of thing that, like psychology, can go from here to there very quickly, depending on who is doing it and what their training background is and what aspect of it they support. But it can be of value. But if you're going to do it, you'll have to interrogate it properly. You'll have to decide who pays for it, what panel of professionals you would accept, what level of training would be considered appropriate. Because a lot of people do psychometric tests now. So there are a number of things to be done before you put in law. But it could be a policy issue that the FLA could adopt as part of their review panel for individuals' competence to handle a firearm. Minister.
Thank you, Chairman. In respect of the suggestion for the psychometric test, I too, like you, have no difficulty with it. I believe it would require some deeper considerations for inclusion in the legislation at this time, and it would, which we are not in a position to make a decision on at this time. Certainly the applicant, if it is that the applicant would be required to submit himself or herself to the test at his own cost, then you'd have to look at who the service providers would be and what would be the standards around that. So no difficulty, but it's a matter that would require some deeper consideration. In respect of the concern by Member Jackson about whether a mere charge in respect of an offense involving domestic violence should be enough to bar an applicant. Perhaps if the matter were considered from the starting point that there is no right to bear arms in this jurisdiction, there is no right to be entrusted with a firearm, and that having regard to the serious nature of domestic violence and what happens in the homes as shown up through the cases that are reported publicly and those that go before the court, for persons who are charged, not merely suspected. So there is a difference between someone being suspected of having committed an offense and someone being charged, because you do have to have evidence capable of satisfying the ingredients of the offense for a charge to be laid, regardless of whether the charge results in a conviction or an acquittal. So this is not a low standard, and it is something that we should view as sufficiently important to bar someone from being granted the firearm while a charge is pending. When the charge is dealt with and come to an end and the matters are cleared up, then the person can reapply. But I don't think this is one that we should lower the standard on. It's not, the clause doesn't say someone who's suspected of having committed the offense, because you move from mere suspicion to a charge when you have evidence to ground the charge and to ground the ingredients of the offense.
Mr. Chairman.
Yes, Mr. Chairman, in relation, with your permission, yes,
Williams.
In relation to the said 58.3c. So, if I'm to understand, Madam Minister, in relation to charged, the impression, what I'm understanding from you is that during the currency of the charge, meaning the life of the matter in court, that person cannot be granted a firearm license. Is that what you're saying? But couldn't C also be interpreted to mean once charged and matter disposed of? Let's say, for example, you know, a mischievous, frivolous spouse, you know, through some kind of jealous motivation or some external, extraneous motivation, makes a false allegation against their partner, and the person is charged.
I understand you to be saying if once someone has been charged, whether the charge is pending or not, it would affect them.
It would affect the person. So even after the case, let's say a judge says it comes before a judge, no case submission is made, or there is no evidence is offered by the Crown, and the person walks free, that there is a record, and the FLA, of course, based on this clause, is going to say, well, you were charged for an offense, even though it resulted in your favor and there was no evidence, we cannot give you a firearm based on that.
That's enough evidence, Sir Minister, before you do the legal side. That's enough evidence for this chairman. He had a first bad judgment in choosing the wrong partner in the beginning. So I don't need any more legal framework. Right?
Chairman.
I'd be complete here. This business going to
Chairman, you have some very extreme personal ideas, but I don't think those should be incorporated in law. You have very extreme views.
Yeah.
I don't think somebody making a poor judgment in a spouse, that should be held against their...
It will not be in law. It's a matter that I expect the FLA to consider in its operation.
Let's consider it. Let's consider it, though, through... Let's consider it.
It's clear. But, no, I'm saying if a man is charged, allegation, that's his problem, not mine to go investigate. The investigators will so investigate.
Minister, Mr. Chairman.
Sorry, remember, 25% of homicide relate to domestic violence. The nature of it, the egregious nature of it, which drives my thinking, is something we cannot police, you know. We cannot police domestic violence. We provide counseling, we provide improved conditions of service that people can go freely and discuss. But you cannot...
I do see where you're going, Chairman, Mr. Chairman.
Sorry, Minister, to chop off his wife head in bed. And therefore, every step must be taken. Every step to protect any such person who there even allusion to from shooting somebody. One life is enough for me. And therefore, if he's charged, if he's reported to be involved, and bear in mind, many of them will go to court even after such event happened and withdraw because of relationship. The whole issue of domestic violence, from a clinical point of view, is a very complex issue. Many people bear it out and will not allow their spouse to go to court and be convicted. Therefore, the government cannot allow any opportunity for that to be breached. And it's not a legal precedent or frame, that's a social condition. And I cannot accept any way there's an allusion to domestic violence, that person is stopped from getting a firearm. The investigators may pursue it. It's not going to legislation. It remains a policy, and it will be policy guidance to the authority, whatever happens.
Minister.
Chairman, just to say, hold on, please. The person may be disqualified or may not be disqualified under that ground, but if the person is of intemperate habits, he may fall under. So one-off situation may not be sufficient, and I do agree that we have to bear in mind that our humanity is characterized by fallibility. But intemperate habits and the risk that is involved in having a firearm in cases where persons are prone to act in a certain way is something that has to be guarded against. So it's not an emotive response, Chairman. What you have indicated is in fact covered under habits, and habits are formed over time and they are part of a pattern. A one-off incident is not regarded as habitual. So that I share your view that though we may be focused on the reality that persons are prone to rashness in moments of deep emotion, it is precisely in those moments that harm occur. So it's not that you cannot have deep emotions that may cause you to react a certain way to it, but to react where you use a lethal weapon is something that has to be viewed with a high level of strictness.
Minister. Thanks for that. No, hold it. Thanks for that. Legal
Mr. Chairman.
But there's a clinical, I'm going to ask the member to just hold that committee. There's a clinical syndrome, and they'd have to get a psychiatrist to diagnose it, where women who are being battered will give you a perfect explanation, will remain loyal to their partner, for a lifetime unless they are rescued by professional personnel. And that is not a law that can be written in law, and that if they end up putting in the community that if such a person appears, then they send him to a psychiatrist for a complete psychiatric investigation. Overview. This is not an emotional issue. It's a real issue out there. And people who are being battered are often remain in relationship. It's 5-10 years before they are killed. We cannot allow a fatal response in that process. A member.
Mr. Chairman, I know particularly the issue of domestic violence is a sensitive one, an important one, and must be treated with sensitivity. However, this whole section where the board has reason to believe, and then it lists a whole series of things: intemperate habits, mental disorder, drug or substance abuse, is otherwise unfit. This is really way too broad and would expose anyone in here to a malicious person just making an allegation and disqualifying. We have had cases when I was minister of a spouse who told an investigator that her partner had a temper and therefore shouldn't be issued a license. When the person appealed and had a hearing, the person said they were just really uncomfortable with the idea of a firearm being in the home. And so they made up this statement as a reason to prevent the person from getting the firearm. Now, by your reasoning, you're saying, well, that person should be disqualified for life because them have a partner who tell lie upon them, even though the person recanted their statement at the hearing to the review board. I don't believe we can just make it so broad, because what you are inviting is arbitrary and capricious decision making at the level of the FLA. We've seen it already, and this is creating a hole that a horse and carriage can go through. The reason we have a review board is so that issues like these can be tested. The reason you have a retired Court of Appeal judge or a Supreme Court judge on the review board, on the review panels, is that these persons have experience and training in determining credibility of witnesses and the strength of the evidence of these types of allegations. So I really don't believe that we should, playing to the gallery today, create any sort of unreasonable exposure to applicants, to any person who maybe just have malicious intent, or, as you and I know, a lot of what is called intelligence starts out as straight gossip. And I don't think we can expose our citizens to be treated unjustly. All of this must be subject to being tested before a tribunal.
Member, Minister, proceed.
Just asking the member whether he has a proposal as to how that criterion may be reworded, because it has to be that someone who is of intemperate habit, not a single-off event, that consideration would have to be given on that limb. So if it is that has reason to believe, that is of concern.
As evidence.
Minister.
Must be evidence, it can't be just reason to believe.
That is hearsay. The answer, no. This is a No, unless you're going to tell me that I must add to the panel, a review panel, and I'm serious about it, that's an emotional thing, I must add the senior medical officer for Bellevue to be a part of the panel in such cases. I'm not doing this. The answer you gave me is a perfect explanation we get from people who are in such situations. I cannot accept any modification of this particular clause at this stage unless you can give me further clinical evidence. The situation is, as I said, is 25% of homicides, which we cannot police. And I cannot allow the government to be complicit. That's what we are doing when you give such a person it. And while the separation of illegal weapons from the regulated weapon must be to make life, quite frankly, easier for the people who are legitimate to pursue transparent and integrity charge. The question of domestic violence, I'm accepting no compromise. The clause as drafted is clear, is appropriate in the circumstances that exist in Jamaica and must be maintained.
So, Chairman, just to respond.
Minister, can I make an intervention before you go on? Minister, you have to look at the clause and see the distinctions. Because when you say that the person has a history of mental health issues, drug or substance abuse, or domestic violence, that can be covered by your intelligence. So that a person in a community, in other words, the woman or the man who is being abused, might not report it to the police, and we know how that goes. But there's a history which you pick up in intelligence. I think what we are concerned about is the other limb, which is that a person who is charged with an offense involving domestic violence is deemed to be unfit without more. The fact of the charge is what we are looking at. And I know that you say you have made up your mind, but I think your mind should be assuaged by the fact that if there's a history, in other words, not, might be not just not charged, but we know in communities, he or she has been hit many times or abused many times. I wonder if that would not cover your concerns.
You see, the situation that exists is pretty much like this. Furthermore, I don't, as the Minister implied, I've had appeals, and most appeals are dealt with by the panel where this charge is totally spurious. But I think it has to be here that the charge, first call, is to refuse. Then you can do the review, if it makes sense. I don't want to modify that, the feeling that, just saying is a lie is gone. It has to be deeply interrogated, because my position is that anybody so alluded to. In the old Jamaican saying, they never smoked out fire. It might be light, it's a little bit facetious to say yes. And I agree that taking it like that, him choose the wrong partner. But these discussions, domestic violence in Jamaica is far more extensive than we have in public space. There are two very brutal and basically primitive criminal in this country that we don't spend enough time to deal with, and it is not as publicly discussed as it ought to be, so we can correct it, is incest and domestic violence, and therefore the bias must be towards, against the person who might be alluded to. That's why there's member cousins.
Looking at this clause in respect of the disqualification by virtue of the fact that someone has been charged or have a history seems to, in my mind, go against the principles of due process, because it automatically disqualifies someone who has been charged. Could we, for example, look at the convicted as opposed to charged? Because the word charged in and of itself seems to suggest that just the mere allegation against an individual without more, without the person who has a right to due process as per the Constitution,
Yeah, but...
And who is presumed to be innocent, that this individual is automatically disqualified without having the opportunity. So I said convicted, and you're suggesting, Minister. I mean, I know, I understand where you're coming from, we understand that this is a very thorny, a very sensitive issue as it relates to domestic violence, but we must be guided also by certain fundamental principles. And one of those fundamental principles is the right to due process. And when we say that somebody is disqualified on the virtue of an allegation or a charge, that means we have totally ignored the person's right to due process. And I say a simple curing of this could be convicted as opposed to charge. And I think that should treat with the matter.
Chairman.
The minister's comment.
Through you, in response, just to note, the provision as drafted in focusing on charge, part of the policy is the FLA should not be granting a firearm license to somebody who is before the court. The court has not made a determination as to the individual's guilt or their innocence. Whilst that is being sorted out, it would not be appropriate for the board to be granting a license.
That doesn't treat with the history. The history there. So it's not about charge alone, you know. I just focused on the charge. But the fact that there's you read it carefully, it says a history. History. That's a bigger factor there, so because a history of domestic violence means that a person may be charged but has a history but was not convicted.
So as it concerns history, the focus there is not whether or not the individual has been brought to the court, because many times there could have been instances of abuse, but that individual was not brought to the court. If that evidence exists, it should be within the remit of the authority to determine whether or not that person is appropriate to be in possession of a firearm.
But the word you just used is evidence. This doesn't say evidence. It says has reason to believe. I would be comfortable if you say who the board has evidence of intemperate habits or domestic violence or so on. But it is where you have removed the requirement for evidence and you have put it entirely in the realm of gossip and hearsay. That is what I object to.
Just in respect of that concern, so all statutory provisions are subject to interpretation, and there are rules of interpretation. If you do not have a word given a technical meaning, then they are going to be considered in their ordinary grammatical meaning in context. And the reason, ordinarily and grammatically, is not mere say-so. I mean, if you look at the dictionary definition, it's a rational ground or motive. It's a statement offered in explanation or justification for something. And I think perhaps, I know there is a love affair with firearm, but there is no right to have a firearm. And what we have to ensure is that the criteria are set and are clear, and that they relate to the risks that are being managed. And the same set of criteria that an applicant is told that he must satisfy will be the same set of criteria by which every application is assessed. You know,
Minister, would you just say, what's your objection to evidence? What is your objection to using the word evidence?
Because the matter is not going before a court of law.
No, but in the ordinary meaning, evidence is whether a belief or a proposition is true or valid. So what's wrong with your
But what's wrong with reason?
No, a reason to believe is, somebody tell me so. That's a reason to believe.
In the case
that is wide open to gossip.
Well, I kind of disagree with you.
Malicious intent.
I hear your concern that we are a jurisdiction prone to gossip, and even people in high places sometimes pass gossip on in the intelligence community, by which others are judged. There is plenty of example, if we even hear to say so, that you wouldn't expect it from people in high office, whispering and sussing to local authorities, foreign authorities, and then people are prejudiced by it. But that is not the conduct we're talking about. And that is not to say we mustn't be mindful of it. It's not mere information that you have, because the information has to rise to a higher level of it being justified and justifiable before it becomes
and then you
reason.
call it evidence.
Mr. Chair, just one.
No,
just
I'm
one
not
quick
accepting the word evidence in this station, member.
Yeah.
And the truth is, as far as I'm aware, the law does provide for people who maliciously malign somebody as a charge. So if the partner feel that they have been maliciously maligned by their partner, there is process for that as well. Go to court.
But Minister, this is not limited to domestic violence. You know, there's a whole heap of other issues it speaks of here. Intemperate habits, suffering from mental disorder, drug or substance abuse.
If someone reports to the police,
these are not limited to domestic
they
situations.
can charge that person, whether they're a friend, partner, or neighbor, with malicious intent. I think
But this doesn't require a report. This requires somebody, a neighbor, to say to a FLA investigator,
yes,
I believe the man smoke weed or take crack. That's all it
low
requires.
level that we hold our institutions to. I know the FLA is plagued with problems over administrations. And I know that decisions taken are questioned, and questioned whether they have been taken on the right basis.
Yeah.
So it is a thorny issue, but there is no
it.
freeing up of an assessment of someone who is applying to hold a lethal weapon. The criteria cannot be set at a low standard, in the same way that it will be expected that those who are assessing the application will assess the application sensibly.
Mr. Chairman, the reason, may I just add my 2 cents to this controversy as to whether we should use evidence or reason. And why I support the formulation as it is this. The board, if we look at the composition of the board, obviously the board is, you know, there's a judge of the former judge of the Court of Appeal, Supreme Court judge. These are
no. You have to make a distinction between the
yes,
review board and the FLA.
These are hold on. Let me just finish.
But you're making a false assumption.
Yes, go ahead.
That composition that we've been speaking about of the review panel, the review board under the statute has certain requirements about a judge, a retired judge of the Supreme Court, etc. But the authority doesn't necessarily have that expertise resident in the authority. It's an appeal panel.
Yes, but even
hold on. Let's just bring a little. I know it's a matter that is causing passionate discussion. So let's look at the scheme. It's not very different. I mean, there are some things that will have to be looked at. The application is made to the board. The board considers the application against set criteria. If the board refuses the application, the board is required to give reason. And the reasons must relate to the criteria against which the person has fallen short. After that, having received the reasons, the applicant is allowed in law to apply for a review of the decision. The review panel is subject to judicial review. And in administrative law, reasonableness would apply. These are principles that are set out in law. All right? So there are safeguards. I know not everyone is a lawyer in the house. And so you'll question some things from a common sense perspective. But I just go back to a starting point. The firearm, use of firearm, possession of firearm at its foundation has posed an expensive risk in Jamaica. There is no right to bear a firearm, and persons who are applying must satisfy strict criteria. And the process is a process that is being made fair, because people are entitled to fair and equitable treatment in the exercise of any function by a public authority. So unless we feel that the thing must just free up and there really is no need to address the harm that has caused us such a huge chunk of GDP on the security front and on the developmental front. We may run the risk of people misunderstanding and thinking that the call is to just free up the thing.
Chairman, sorry, I've been trying to come in.
Go ahead. I'm not trying to figure it. Oh.
Mr.
Chairman.
I was on the floor and I was actually drowned out.
Member Williams. No,
yes.
Member Samud have been trying for some time, then call Mr. Williams.
I was on the floor before Minister Malawi Fort, but I yielded. Trying to... duality of focus is admittedly. But the Chairman, I think the core of the issue, I think, is the divergence on the doctrine related to the holding of firearms that you see playing out from the positions being put forward. The policy and the doctrine that has played out itself in the draft legislation that we have here shows clearly that we have attached a very high standard because we view it, the holding of firearm, as a particular privilege, a privilege that requires persons to prove A, that they are capable of managing it, and B, that they are deserving of such privilege. Now, the principle of equity and fairness in how that is evaluated is certainly important, but I don't believe that for something that we believe, as we have stated, that we believe is a privilege, that's something that you require more than a reason. And I think, admittedly, Member Bunting, I don't share your view on the intelligence discussion, because yes, some of it does start as gossip, but I think we need to give more credence and be fair in our evaluation of the intelligence community, that when things reach the stage where we describe it as an adverse trace or as intelligence, it is because the systems that we've put in place between the varying arms of the state have indeed evaluated and assessed it to be a real reason. So I don't think it needs to go to the threshold of evidence. So that's my position, Chairman.
Chair.
I didn't get a chance, Mr. Chair. You know, and I won't be long. I just want... Guided. Yes, Mr. Chair. You know, I was developing on a point, and I was stating, yes, I was...
Member Williams and Member Jackson.
Yes, I was positing earlier, Mr. Chairman, my reason for supporting the formulation as it is, that in my view, it is sufficient. And the reason I say it is sufficient, in my view, is that the board, there is a presumption that the board, given its composition, would have men or women, members.
The board or the authority?
No, the authority.
We need to make a distinction.
Yeah, I think you're getting a little bit of... The board is the review panel.
Yes, but the authority doesn't it comprise the board as well?
That's what I say, use the authority instead of board. Use the term authority.
To avoid confusion, use the authority to be the first
the board of authority.
Panel.
Yeah.
So my question is that member Bunting sought to, well, outline or correct me in the sense of the composition. So I just want to make it clear. Isn't it at the third schedule, the board of authority is comprised of a retired judge of the Supreme Court or Court of Appeal? Is that the same board we're referring to here?
Yes, that's correct.
And that's the point I'm making. The point I'm making is that the composition of the board, it is of such that there are eminent jurists who have been trained in the whole question of reasons and evidence, and I'm sure that they would be in a position to determine, based on their expertise and experience, whether an allegation as whether a factual position, whether something that is being submitted in terms of a person's habit or personality is based on mere frivolity, you know, without more. So So in my view, I think the board must be trusted in this regard to determine the reason, whether the reason has substance.
Board of the authority.
Yeah, the board of authority must be able to determine whether there is substance to this allegation of intemperate habits. And it is in that regard, Member Bunting, that I am satisfied with reason as it is. Yeah, in addition to the definition outlined by my colleague, Minister.
Mr.
Ford.
Chairman, the definition of the board of the authority here doesn't depart significantly from the current definition. For example, a retired public officer isn't necessarily a retired director of public prosecution. It may be, but it isn't necessarily, and it often hasn't been. And this same composition, their decisions have been overturned on many occasions by the more distinguished panel, which is the review board. So just because you follow this this composition here as set out in the third schedule doesn't mean that errors are not frequently made.
Just to clarify that it is the board that will make the determination of the grant or denial of the license. Perhaps, Chairman, the real issue, as has unfolded in the reports and of the Integrity Commission that is before the House, is what we need to look on is the role of a minister and how the exercise of discretion may impact on matters that are reasoned and assessed by a board or a review panel. I think that probably is where the real angst is.
In this whole thing about being charged and not being convicted, and that is acted upon, let me CLA is here, the FLA is here. If a licensed firearm holder
Member Jackson, we're going to take the FLA. The FLA is a creature of policy and government policy.
No.
So while the minister doesn't interfere in the operation of the LA and should not do so, and we are even looking to tighten that rein, there's still a creature of policy and the law.
No, man,
so
I'm not.
They have the law to they abide by the law, and they also have to take policy directions from the government, which is reflected in the regulations as they go forward. That's just the reality of the thing. So,
I just want the benefit of experience in this matter, hence my engaging in the FLA, since they are involved and have been involved in dealing with matters of this nature. A licensed firearm holder is charged for an offense involving the firearm. When that person is charged, my understanding is that the FLA does, I don't know if in all occasions, will take possession of the firearm. Or in some instance where they are charged, they take possession of the firearm. It's now in their care. The matter is before the courts. The matter is dismissed subsequently in the courts. Man found not guilty or no case submission, whatever the description is, but preserves his innocence in the matter. Is it a matter of policy and practice that that firearm is immediately returned to the firearm holder upon the court's adjudication in a matter like this?
Thank you. Chairman, the operation of the FLA is very complex as it relates to complaints, and I'll deal specifically with the member's question about a charge. We had an allegation, Member Jackson, of a correctional officer who behaved violently towards his spouse. And the firearm was taken, investigation was conducted, the wife refused to cooperate. We returned the firearm. A few months later, he killed on Agley Park Road and killed himself in front of his child. We have several of these cases. One year we had 4 murder-suicide by license holder. Persons who are charged and go before the court from time to time are found not guilty. However, they are sometimes on point of technicality and law rather than on facts. The FLA still conducts an investigation because what we are doing is an administrative review to find out that the person is fit and proper. We are not convicting the person of anything. We are finding out that the person's temperament, behavior warrants him continuing to have a firearm. So the fact that a person is charged 5 times and never been convicted does not mean that he maintains a fit and proper criteria for the FLA to really keep the firearm.
Member Jackson, I think there are two coming out. Before you cut, there are 2 things we have to do because we are staying on a debate, which I really have not found anything so far in a long debate, even partially persuasive. The issue is, I'm not very serious. I'm sorry, no, I mean that because, first of all, when you refer to a court station, not guilty is not a distinction of innocence. We know that completely. Not in innocence. And innocence is what I'm looking here, number 1. Number 2, we are dealing, as you remember, the panel, the FLA board, the authority, yes, will have more mistakes than the review panel for the simple reason that they have the volume to deal with. They take the reports from the investigators and they do what's a thorough and good review, but they will have to go through much more quickly than the review panel, which will have to go in further depth to analyze. Because the same quality board, and it's a bit bigger for the authority. That's it, because the Supreme Court judge is still there. Maybe the person well known that is getting a bit up in age and not as active as the president, the former president of the Court of Appeal. But the standard is pretty much the same, and the fit and proper review is even more rigid now as we go forward. It's a practical situation. But as I said, the issue of domestic violence has become, it's beginning to get to the fore a bit more, but it's something we used to take as almost a part of the cultural activity. You know, people, put it bluntly, man say, my woman, like they own them, and they have a right to do what they wish to do. That is a inference to a culture that has to be executed and eliminated. And nothing must be done to allow that the government in any way become, any aspect of the government allows for a fatal response in a domestic dispute. In fact, if you ask me, we should be looking at limiting the use of machetes, not talk about gun. I should maybe charge a license for anybody who is not operating a registered firearm over machete. That's where we should be going. Instead of talking about
before you reach there, I just want to acknowledge the point raised by Mr. Dallin about going beyond being convicted or not in other considerations for holding firearm. I consider that reasonable, right, in terms of arriving at determining whether or not the fit and properness of the person is in place outside of whether or not they have been guilty of a charge, that is laid before that. So I just want to posit that.
Chairman,
Mr. Chairman, you keep coming back to this issue of domestic violence, and if we think that is something that is of particular importance and sensitivity, and want a special carve out for that, but because of that, include things as general as intemperate habits, drug or substance abuse. This is not dealing or trafficking. This is drug or allegations or reason to believe. Can't we take out that domestic violence, since that is where we have the major concern, and treat it specially, and have all these otherwise unfit to be entrusted in a different clause?
The issue raised, Minister, now you have brought but the clause that was brought to my attention and asked for the comment, and the Minister in leading discussion on the raised it was Section 3, Section C, which relates specifically to domestic violence. That is how the debate discussion started. And 4, which broadens it to cover a number of areas. And I said we'll leave them as they are, which was C and 4, DC and 4 that was being debated. Now, open to discussion, intemperate habits, so you want to structure it, all those issues. Intemperate habits relates to domestic violence as well. But that was specifically the clause that was brought to the attention of the chair for discussion, C and 4. The Minister might want to comment on.
Chairman, my recollection is that the formulation of the policy behind the law took time, and it's based on data collected, actual cases assessed. We're seeking to put in place new provisions that will address some of the most pressing challenges that we have had in this nation. I appreciate that we are a broken society. A lot of the harm in this society, the data show, happens in the homes, the places where people are supposed to be protected. Sometimes it's the most violent of places. I go back to the starting point that there is no right to bear a firearm, which is a lethal weapon. Persons who are applying have to be put through deeper vetting. That's what the provisions have set out. They also, care has been taken to ensure that persons know the criteria against which they're going to be judged. Now, we who legislate are not the only people with sense. And in fact, sometimes our conduct would cause people to wonder whether we have any sense at all. We have to give the benefit of the doubt when we create public offices and we say that in order for you to hold the office, you have to have certain qualifications. Because the qualifications, through training and experience, matter in how you discharge the functions of office. And, many things are being said, and I understand the concern. But I cannot help but wonder whether the call is going to be interpreted as a lowering of the standard and a lowering of the bar to just free up the thing so any man who wants the firearm can just get it, forgetting the problem that the firearm poses. Because once you get the firearm lawfully, you're treated in a little different way. So before you get it, I'm just kind of wondering if something I'm missing about the deeper vetting that would be required. Because we have examples now, currently in the news, of major concern being expressed about people who have been entrusted with firearms license and their fitness to hold the license by virtue of their antecedents is called into question and of serious concern in all quarters of the society. People who apply and then they expunge the record, they go back and apply, all kinds of things. What we want to ensure is that the function that is to be exercised by the public authority is exercised in accordance with the law.
And what we want to do is to remove the subjectivity, because that's
take
where
away
the
anything from
corruption
ministers
comes in.
who will overrule
Allow me to
things.
speak. I allowed you to speak. It's the subjectivity in the law that allows the corruption to come in. So my point is, whatever the standards we're setting, let us make those be objective standards and not leaving it to the widest of discretion at every level of administration. That is the point. Not that we must lower the standard, but we must establish an objective standard that the public can have confidence in, that they do not have to bribe an official in order to get a fair treatment by the authority, but that there is an objective standard against which, if they need to apply to the judicial system for a hearing, they know there is an objective standard and it's not left entirely or principally to the discretion of corruptible officers?
Of the criteria set out would be considered non-objective.
Oh, that is the same approach
Chairman,
and decision and discussion related to minimum sentences.
We're going to circle
discretion, setting minimum standards.
Please, I'm going to ask.
No, I'm not
senators,
I'm not commenting on.
I know. I'm just asking. I said I'm going to allow your comment and then I make a final comment because we're going to circle.
I think that the minister must be cautious as to how she words some of the things she says. Yeah. I take umbrage at the fact that this discourse is being treated as an attempt to free up the team.
No,
the Joint Select Committee.
We all share a common thing with
the
this.
Joint Select Committee is supposed to give the opportunity to ventilate all the concerns, to give us a basis for taking a decision. And I think that the whole process, which I highly commend, is being undermined. If you take a position and it seems as though you are, you're being lax, you're giving latitude. And certainly, I want to make it clear that I'm not here to free up anything.
Oh, Member Senator,
I want to enjoin
Senator,
please,
Senator.
Sure.
No, I don't. I fully agree with the comment. Nobody, I don't think there's anybody in the room or I've gone further in my comments who is seeking to free up the issue. Some of our opinion, I think there has to be significant level of discretion given to the authority of both the board and the review panel, because that's why the law prescribes the character in the videos there. So discretion, they have literally maybe the wrong term to use, but I'm not a lawyer, quasi-judicial position they adopt. That's why a Supreme Court judge on the panel, and it's discretionary. In this situation, it can't be all empirical, because if you wait on the empirical data to come, it means you're going to wait on a number of murders, quite frankly. So there's a significant amount of discretion. I think the propensity for violent society is one which we are just beginning to evaluate, not just the incidence of violence and murder, but the propensity of our society to resolve issues by being violent is one that we have to maintain a strong messaging to. And this is part of it and has to remain a part of the law. The issue of drug abuse is not an allegation, I expect, and if I interpret it wrongly, history of drug or substance abuse is something that is proven clinically. So anybody who is charged, it is an easy clinical call. So I didn't see this. It wasn't brought up before the member bring it up, but if you check a man of drug abuse, then you must provide the evidence that he is in fact an abuser of alcohol. He's in fact an abuser of ganja. And, something like marijuana remains in the blood system for up to 6 months. So finding and checking him for it if he objects is easy. That can follow a very empirical basis. The issue of violence is something, unfortunately, we don't have the only data we have is the broad social data. And there's no question that Jamaica has become a very violent society, and the violence in particular against women is particularly brutal. And that's just the reality out there. So any law I see, it has to be biased in that direction. And I use that term without being emotional. I'm saying I have to err on the conservative side rather than the liberal side. So I understand the points being made, but given the circumstances I have to deal with, and I think the former minister would have had some insight to it as well. Maybe, the nature of his own concern may be different, but the level of violence in society is of great concern. I had await the report of the Violence Prevention Commission recently by the Prime Minister to give a report, but the data is clear that this society has extremely high propensity towards violence. School children are stabbing each other. Students are attacking teachers. Boyfriends are killing their baby mothers. It's just pervasive, and therefore the message must go. Cannot be all empirical, I'm sorry. The messaging is crucial, and what we are saying, anything that can perpetuate violence will be brought under extremely rigid control, including a level of discretion given to a panel that the country can have confidence in, and remove the only issue removed from any discretion by any political directorate, because it is too sensitive to do so, and then there will, despite our elected government and the democracy, which must retain a certain level of executive responsibility, would remove the discretion in this case. And I think that is strong enough to assure the country there will be no, well, for one word, there'll be no witch hunt for people because there are rumors and allegations against them. But it'll be handled with the responsibility and sensitivity. But it will be, as I said, managed a way that seeks to add extra layer of protection to those who are being abused.
Chairman,
But I don't view anybody's comments as being seeking to undermine. I think we all appreciate the problem, but sometimes it has become so pervasive, we are a little bit more, almost too objective about it, literally. I'll be quite frank with the members.
Chairman, there are 3 or 4 issues in relation to this subclause that the discussion has put on the table. One, the use of the word reason at 4 in the chapeau at 3.4. Reason to believe. This is not information. Reason takes it to a high level. And the request was that reason be substituted with evidence. We're just recording at
We are saying evidence
no,
is
we're
something
not
that...
changing yet, Chairman. We're not changing anything at this stage. We're looking at what the request is that has come out of the discussion, the very spirited discussion.
No, yes, and a good discussion,
right.
But we're exactly referring to because
Page
evidence,
46.
Evidence is a court of law decision in Jamaica is very high, and we accept it for the court of law, and I'm not accepting it for firearms issuance. The evidence, the bar for evidence in Jamaica is high, and I'm not complaining. And we have to get to a policeman more equipped, better trained, and raise the bar. The bar for evidence in Jamaica is extremely high in any society, including some very democratic models. But it's a good thing, right? But when we get to deal with these things, to introduce, I need to be clear which clause you're suggesting that in Minister. This is a court issue. So they go to court and give evidence if necessary.
All right, Chairman. So that was the first issue, reason, because of the concern that spurious information,
to believe, yes,
untested, could sway the board and cause the board to believe that someone is of intemperate habits when it is not so.
Yeah, I see the way you're talking about it. Sorry.
We've pointed out...
Let me give an example, Minister, which is not even discussed in our society today, and I haven't witnessed it firsthand, not anecdotally. As we discussed the legalization, and I was maybe the very first member of parliament, first political leader to ask for decriminalization of ganja. I got back in the debate. This was 1976. I wrote the speech from Mr. Hugh Shearer, which led the way, later than that. The first call when we lost terribly, yes, 76. And we had few MPs. Can't give you that. I sat down with a friend and Mr. Shearer gave the speech at the first public event, which was hosted by Young Jamaica. No one won't forget it. Asked for the decriminalization of ganja. So I'm not any bias here, but ganja has a particular syndrome, which if you have a history of use, you need to check. It unmasks psychosis on the negative side. It's like anything. You have allergies for drugs and you have allergies for aspirin, which is 36 allergies reaction to aspirin. But aspirin is sold across the world. I'm not in this to abandon it, but psychosis is something that can be unmasked by the use of high THC ganja. When a man goes psychotic, he kills his friend, he kills his mother, he kills anybody. I was there in emergency hall when I remember a couple of young men came in from the middle class, that working class people, and his friend went off, he got a psychotic episode, and he bit off his thumb in my presence and dropped it on the floor. I was the one who went up and cleaned it off and give him back some kind of a shape on his finger. They were best of friends, that's why I was that close to him. So, things like history of something, but it's something can be proven. So I quite agree. We can know, but it has to be there of concern, because when he's off the product and he's not even taking medicine, what you might call cannabis, it's a different thing. If he smokes high THC content and goes psychotic, he's totally gone. Right? It's an established clinical syndrome. So all these has to be borne in mind when the law is structured this way. It's always a minority. And Jamaica is famous not for medicinal ganja, because we abandoned that when Dr. West lost his patents here, or didn't use his patents here, Asbasol and Cadasol, which are good products. We are famous for high THC ganja. And it can be used commercially, but it has to be managed. But it has to be borne in mind the side effect of high THC ganja can be unmasked psychosis in the population.
All right, Chairman.
Is rum included in this definition? Alcohol?
I expect that it's a drugs and some abuse, that rum must be there. Rum.
I'm just asking for information. Would this cover alcohol?
I would expect so, but because I regard all the substance abuse, addictive products, you know. Right?
Chairman, in the interest of time, just to get back to the clause under consideration. Right, so notwithstanding different views, I think all of us are agreed that great care must be taken to ensure that what is contained in the law is what we intend. There may be disagreements on the policy behind it, but I think we're all agreed of the great care that is required in the use of the words and the general language of the legislation. So in respect of D, it was to replace reason with evidence, and we have indicated that it is not mere information, and reason takes it to a little higher level. Right. And then there is a request for a special carve-out in respect of domestic violence, having regard to realities within a home where certain persons may, in moments, make allegations and are not prepared to carry it through. So two things we will have to assess is whether a failure to carry through or a recanting means that the allegations were not true in the first place, and that the person may not really, there may not be an issue. And those have to be assessed.
Minister is saying we change the word reason to information.
No.
Oh.
No, it's at a lower level. The reason means that you're going to assess the information.
Okay.
Right. I'm just pointing it out that there is
not evidence.
It's not just a little gossip here or a little thing. These applications come by way of formal process. I don't know if in the past persons have been pulled aside and whispered in the ears that this person is not able to get. I am of the understanding that certainly going forward, if not what has been, that there is a proper process, a regular process, even if it is by way of correction of past approach. There's a prescribed manner in which the applications will have to be made and the information supplied, so that in refuting or challenging a reason for refusal, then the applicant would have an opportunity to provide information that can be weighed in the other direction. Because that's kind of one of the reasons why you give reasons, written reasons, and you allow a process in review. Is it that something that can be taken into consideration was not before us, and it is now placed before the body? All right? Right. So and then in respect of 5 is whether otherwise unfit to be entrusted with a firearm is too widely cast. The explanation you have given is that this category is intended to cover intelligence information, among other things. But there is usually a catch-all phrase in the event that there is something that may properly disqualify someone, but it is not specifically provided for. And that's how legislation is generally written of the same type.
Thank you for that, Minister. So we can proceed with the next item on the next section. Look, just happy that members recognize and continue to keep in their mind. And messaging is part of this bill. This country has too high a propensity for violence. It's impossible to remove all weapons from society, but that would be the idealistic and utopian. But that's reality. We just have an extremely high propensity for violence, and we cannot be totally empirical in approaching it. We make mistakes. So, Minister, you want to go to the next section?
4.
Clause 58.4. No firearm authorization shall be granted under this section unless A, the board is satisfied, 1, that the applicant is a person who can be in possession of a firearm or ammunition without danger to any person or to public peace or public safety. 2, as to the applicant's proficiency in the use and management of the type of firearm in respect of which the application is made. 3, that the applicant has made adequate provision for the safekeeping of the firearm and ammunition in respect of which the application is made, having regard to the firearm authorization applied for. 4, that the applicant resides or is ordinarily resident in Jamaica, except in the case of an application for a firearm user's special certificate. B, where the firearm in respect of which the application is made to the authority is already in the possession or control of the applicant has made the firearm available to the authority for inspection, and C, the applicant has paid the appropriate application fee. 5, the board shall, within a reasonable time, notify the applicant for a firearm authorization that may be granted under this section as to whether the firearm authorization has been granted or refused, and A, in the case of a refusal, the notification shall include the reason for the refusal and inform the applicant of the right to appeal against the refusal, and B, where an authorization is granted, issue the authorization to the holder in accordance with Section 66. 6, the grant of a firearm authorization under this section shall be subject to the prescribed terms and conditions and such other terms and conditions, if any, as the board considers appropriate.
Just a reminder, Chairman, that out of yesterday's deliberation, we were to consider whether any category of authorization would not be subject to a review, including the manufacturer's license, transshipment and transit, those that would be in the hand of the Minister for grant. Just a reminder. So that would have an implication on 5.2, how we word that.
Yeah.
59.
To exclude the manufacturer's operation, all right? That can be done.
59, grant of firearm export permit. The board shall not grant a firearm export permit unless the board is satisfied that the applicant therefore includes evidence that the application therefore includes evidence that the appropriate authorization is granted for the importation of the firearm or ammunition, as the case may be, into the country to which the holder intends to export from Jamaica that firearm or ammunition. 60, grant of firearm manufacturer's license. 1, where an application for a firearm manufacturer's license is submitted to the authority under Section 57, the board shall in writing consult the Commissioner of Police, who shall give the Commissioner's views in writing to the board, and thereafter, if the board decides to recommend the approval of the application, submit the recommendation in writing to the Minister, together with the written views of the Commissioner. 2, the Minister shall, if the Minister considers it appropriate to do so, submit the recommendation made under subsection 1 to the Cabinet for approval. 3, where a recommendation under subsection 1 for the approval of an application is approved by the Cabinet, the Minister shall advise the board of the approval and the board shall grant the license.
Chairman, just for the report to recall the extensive discussion on this matter yesterday, so this entire clause will have to be revisited.
61, grant of firearm users' employees certificate. 1, subject to the provisions of this Act, the board, A, on the application of any person in accordance with Section 57 for a firearm users' employees certificate, and B, with the written consent of the holder of a firearm user's business license in respect of a particular firearm specified in the application, may grant the certificate to that person. 2, a firearm user's employee's certificate granted under this section shall authorize the holder to keep, carry, and use, in connection with the business of the holder of the firearm user's business license referred to in subsection 1, the particular firearm and ammunition specified in the certificate. 62, grant of firearm user's special certificate. 1, upon an application made under section 57, the board may, after consultation with the divisional commander, grant a firearm user's special certificate to a specified group or person, authorizing that group or person, as the case may be, to possess a firearm or ammunition for restricted use as specified in subsection 2. 2, a certificate granted under subsection 1 shall be restricted for use as specified in the certificate and within the areas specified in the certificate, which may include A, firearm shooting ranges, B, gun clubs, C, the set of any theatrical film or television production, or D, the location of an athletic meet where the firearm or ammunition is to be used to signal the start of an athletic event.
Just to ask, is ammunition used in the signaling of athletic event for the gun start? Can we just check that, please? So it's a blank? Okay. All right.
Information. So the employees who grant this permit and looking to hold, keep that. Does the FLA carry out any assessment of these persons? Or should I say, we talk about psychometric testing earlier on, having that mental capacity to
Due diligence of the employees that are to carry the arm.
each of them, due diligence is done on each employee who is to be granted this certificate. So not just on the basis that the employer makes the request, but you would do your own assessment of these persons.
We carried out extensive checks, including criminal background checks, as well as intelligence checks on the individuals also.
Thanks. That could be a loophole.
63, grant of firearm user's special permit. On the application of any person who is the holder of a firearm user's license, the board, in consultation with the minister, may grant to that person a firearm user's special permit, authorizing that person to carry A, upon the occasion specified in the permit, and B, during the continuance in force of the permit, and then these words are to go back to the margin, in any security restricted area specified in the permit, the firearm and ammunition in respect of which the person is the holder of a firearm user's license. 64, grant of firearm disposal permit. 1.
Just before you move on, would this cover, for example, 63, where you have, say, a foreign government official traveling with their close protection team? Would they fall under this section, or there's another section that would deal with that?
It's not under this section, it's a different section.
What was it? Could you point me to that section?
So there is at clause 111, there's action exemption, but there's a process which deals with, which sets out how we deal with those individuals.
In clause 111, you said? 111?
111, right, that's the exemption clause.
Okay, thank you.
My understanding of the policy is that special consideration would be given, and it wouldn't be an outright exemption, but a special restricted permit, not an outright exemption. So let's just flag that for consideration. All right.
If you look at 111E, Minister, paragraph E, it says to such firearms and ammunition, the property of government of such other country in such circumstances, right?
I read it.
And the minister is the one that actually grants those authorizations. There is a, what's it called?
Before you do that, the
right,
minister
Minister
grant the
knows.
authorities with the full investigation from the Protective Service Division and the SIB, whatever it is, too. Right?
Just make a note that we may need to just revisit clearly to enumerate which form of authorization is granted by the minister and what is the process that is used to satisfy that the grant is to be made, regardless of the category.
'64, grant of firearm disposal permit. 1, the board, on the application of any person who A, is the owner of any firearm or ammunition, or B, is acting with the consent of the owner of any firearm or ammunition, and who submits with the application proof in writing of such consent, may, these words should go back to the margin, may grant to that person a firearm disposal permit authorizing the person within 30 days after the grant of the permit to transfer or to sell the firearm or ammunition. 2, a permit granted under this section shall specify the particular firearm or ammunition as the case may be in respect of which it is granted. 65, grant of antique firearm collector's license. Upon an application made under Section 57 for an antique firearm collector's license, the board shall, in order to determine whether the firearm concerned is incapable of being discharged, consult with the institute or another entity with expertise in firearms, and if the board is satisfied after such consultation that the firearm is incapable of being discharged, the board shall A, so certify, and B, after making the certification, grant the license to the applicant. 66, form of firearm authorizations. 1, every firearm authorization granted by the board shall A, subject to provisions of this section, be issued to the holder in the prescribed form, B, contain the prescribed particulars, and C, specify the prescribed terms and conditions, and such other terms and conditions, if any, as are imposed by the board.
Just checking, what are the provisions? Oh, all right. I'm intervening prematurely.
2, every firearm export permit issued by the board shall specify A, the type of firearm or ammunition, as the case may be, that may be exported under the license. B, the period during which the firearm or ammunition may be exported. C, the destination to which the firearm or ammunition shall be exported. And D, the manner in which the export shall be transacted. 3, every firearm import permit issued by the board shall specify A.
Before you continue, I'm just saying this section really exports primarily for sporting firearms, and they have specific time and there was a process to apply on a given granted permit. It's different on transshipments, just before any question on it. And it's pretty routine now once they investigate it, approved by the FAA, and then get the approval of the minister. Continue.
3, every firearm import permit issued by the board shall specify A, the firearm or ammunition authorized to be imported, B, the source from which a firearm or ammunition may be imported, and C, the period during which the firearm or ammunition may be imported. 4, every firearm manufacturer's license issued by the board shall specify A, the place in Jamaica where the firearm or ammunition, as the case may be, is authorized to be manufactured and stored. B, the type of firearm or ammunition, as the case may be, authorized to be manufactured. And C, the place in Jamaica where the firearm or ammunition may be sold. 5, every firearm shooting range license issued by the board shall specify A, the location of the facility at which the shooting range is authorized to operate, and B, the supervisor authorized to manage the facility. 6.
Just curious, Chairman, you just mentioned section, I think 3, that deals with persons like the sporting people who are traveling with their firearm for those events. When they are returning with the firearm, right, do they have to go through a similar exercise, or is one done simultaneously when they are applying for the export?
Which we give no covers, but they return. But go ahead.
Yes, Minister, you're correct. We do import, export. You're
At the same
exporting,
time?
yes, same time.
Okay.
To verify that where they're going is acceptable and that there's an authorized venue, etc., etc.
I was just more concerned about the administrative or bureaucratic process, that they just do one thing at the same time.
6, every firearm trainer's license issued by the board shall specify the type or category of firearm and ammunition that the holder is authorized to possess. 7, every firearm user's business license issued by the board shall specify A, the type or category of firearm or ammunition, as the case may be, that the holder is authorized to possess and use, and B, the business or commercial operation, as the case may be, for which possession and use of the firearm or ammunition is authorized. 8, every firearm user's license issued by the board shall specify the particulars of the firearm or ammunition which the holder is authorized to possess and use. 9, every firearm user's permit issued by the board shall specify A, the type or category of the shotgun, air rifle, or ammunition that the holder is authorized to possess and use, and B, the principal holder of the firearm user's license in respect of that shotgun, air rifle, or ammunition, as the case may be. 10, every gunsmith's license issued by the board shall specify A, the activities authorized to be conducted under the license, and B, the place at which the activities authorized to be conducted under the license are to be conducted. 67, application to minister for certain firearm authorizations.
So the permit is only for that category, the user's permit? It's only for the types of weapons that you have here?
I did that, but that's basically what I'm aware of.
I just don't understand.
Yeah,
because
here.
I noticed that a revolver and so on not on
No,
it.
that is where you get, that's where they discuss about pistol shooting and rifle shooting.
Okay.
These permits are given to juniors so the air guns and the shotguns can be used with the user's permit.
Okay.
So that's why they're referred to here.
So what do the security companies use for their guards?
No, they come under the first regime we had spoken about. Business, the
Firearm employee certificate.
Employee certificate. This is strictly for the juniors, as we have agreed, air rifles, shotguns.
'67, application to minister for certain firearm authorizations. 1, an application may be made to the minister under this section in respect of any of the following firearm authorizations. A firearm transit permit. B, a firearm transshipment permit. C, a firearm destruction authorization. D, an ammunition destruction authorization. 2, every application for a firearm authorization under this section shall be addressed to the minister and shall A, be submitted in the prescribed form and manner. B, contain the prescribed particulars. C, be signed by the applicant. D, be accompanied by the receipt for payment of the prescribed application fee. And E, be accompanied by such other documents, if any, as may be prescribed. 3, an application for a firearm transit permit or a firearm transshipment permit shall include evidence of the appropriate authorization from the country to which the firearms or ammunition are to be transited or transshipped, as the case may be, from Jamaica. 4, where authorization is given under this Act for the export, transit, or transshipment of any firearm, ammunition, or other category of conventional arms from Jamaica to another country, the relevant authority shall provide to the appropriate authority in that other country such information as may be prescribed, and which shall include the particulars as to A, place and date of issuance of the authorization, B, the country of export, C, the final recipient, D, the quantity of the firearms, ammunition, or other category of conventional arms as the case may be, and E, if any transit through any other country is intended, the countries of intended transit. 68, grant of firearm authorization by Minister. 1, on an application made to the Minister for a firearm authorization under Section 67, the Minister may grant the authorization if the Minister considers it appropriate to do so, and A, the grant shall be subject to such terms and conditions as the Minister may specify in the authorization, and B, the Minister shall cause the authorization to be issued to the holder thereof in such form as may be prescribed. 2, the Minister may revoke any firearm authorization granted under this section if the Minister considers it appropriate to do so. 3, every firearm authorization, the grant of which under this Act requires the prior approval of the Minister, shall be subject to such terms and conditions as the Minister may direct to be specified therein. 69, firearm destruction authorizations and ammunition destruction authorizations. 1, where the authority or any other relevant government...
Just before we go, Chairman, just a reminder that we are to take another look at 68, right? Just for the record, because...
Firearm destruction authorizations and ammunition destruction authorizations. 1, where the authority or any other relevant government organization applies for a firearm destruction authorization or ammunition destruction authorization, the application shall A, state the particulars of the firearms or ammunition as the case may be to be destroyed, including the type, model, caliber, and serial number. B, in the case of an application by the authority, state whether the firearms or ammunition, as the case may be, are in the possession of the authority in the circumstances listed in Section 102(1)A, B, C, or D. 2, where the relevant authorization is granted, the authority or other relevant government organization, as the case may be, shall A, complete the destruction of the firearms or ammunition, as the case may be, within 60 days after the issue of the authorization under Section 68 in respect thereof, and B, within 3 days after the destruction, send a report thereon in the prescribed form to the Minister. 3, in this section, other relevant government organization means any ministry, department, or agency of government that is engaged in the handling of firearms by virtue of its functions. 70, duration of firearm authorizations. 1, a firearm license granted under this part shall, unless otherwise provided by this Act, continue in force for a period not exceeding 5 years. 2, a permit or certificate granted under this part shall continue in force until the activity authorized to be done by the permit or certificate has been done, or until the expiration of the period specified in such permit or certificate, whichever occurs first. 3, in this section and Section 71, firearm license means a firearm broker's license, a firearm dealer's license, a firearm manufacturer's license, a firearm user's license, a firearm user's business license, a firearm shooting range license, a gun club license, a gunsmith's license, a firearm range operator's license, a firearm trainer's license, an antique firearm collector's license, a firearm user's restricted license, or such other license in respect of a firearm as the board may grant with the written approval of the minister.
As you go in the center, just to mention from 69, I think it was, the board will be getting cutting machines that the destruction of firearms that has to be destroyed will be more efficiently done. It's still a challenge when we go to JDF. So just for information, a modern cutting machine that can cut up the gunmetal is tough, so you don't destroy them so easily.
71, renewal of licenses. 1, a firearm license granted under this part may be renewed by the board if A, the holder of the license makes an application for renewal to the authority in the prescribed form and manner. B, the prescribed renewal fee is paid. C, the holder is not liable for any fee payable under this act, remaining unpaid at the time of the application for renewal. D, the holder has not breached any of the terms or conditions of the license. And E, the board is satisfied that 1, the holder remains a fit and proper person to hold the license, and 2, all other requirements to be fulfilled by the holder for the grant of the license remain fulfilled. 2, the duration of a firearm license on renewal shall be 5 years. 3, where pursuant to subsection 1, the board refuses to renew a license, the board shall forthwith give written notice of the refusal, including the reason for the refusal, to the applicant. 4, on receipt of the notice under subsection 3, the holder of the license shall, without prejudice to any appeal that may be made under this act, forthwith surrender the license to the authority, together with all firearms and ammunition in the possession or control of the holder, and to which the license relates. 5, a holder who...
Query, Your Chair. I see here, yes, that too. The board's refusal on giving notice, fine. Is there any time specification that the board is obliged to tell the applicant that they are refused to grant it, and in the same breath, somebody applies for a license?
What clause, remember? What clause are you referring to?
71.3. Yeah, 71.3. It sets out, it's not here, I'm just asking for information. If while the board, what I like about this clause, it sets out, for example, if it refuses, it must give reason, so the person is not there in a limbo, having made an application for renewal. But another dimension to that I'm interested to know is the time frame. You make an application for renewal, can it sit with the board indefinitely, and they're wondering if and when they're going to grant it? Granted that reasons were established why they wanted it in the first instance. And I'm going back a little for the application in the first instance. If there's any requirement, I know in government from some years ago, we had adopted a 90-day turnaround time for approvals in government. Does that hold with the FLA for applications? Granted, I know the 90 days is going to start to run after all the required documentation is submitted, not when the application is initially made.
Yeah, there are two things here. If I take 793, there's a refusal, which I think is given almost immediately sometime. If it's not given, then they can get it very quickly.
No, I want more certain.
Yeah, I'm not denying that I'll be seeing more certitude. The granting of a license has the one that has taken undue time, and we are hoping we can set this. So
I'm going back a little.
I'll allow the FLA to comment.
Chairman, so the provision as drafted, it requires that the board must forthwith notify the individual. We haven't prescribed a specific date. We haven't prescribed, say, 3 days, 5 days, or 7 days. But the obligation is that they must forthwith, signaling a sense of immediacy.
As for renewal, right? They must get it same time. But I'm talking about now when they apply for a firearm license, there has to be a limit. And I don't think we have done that, but we ought to have that in there. Can you comment?
Where, Mr. Bailey, in regards to following up on the chairman's point, but while contemplating that response, forthwith, I think I have a good appreciation what it means. but then one can be very subjective in that interpretation. Forthwith don't mean 2 weeks' time or 2 months' time.
Well, it shouldn't, but in terms of the interpretation, it's still having regard to the circumstances, but forthwith is to signal immediacy. In relation to the other issue that you raised, Minister, concerning the application and the time frame within which they are supposed to notify the individual of the refusal or grant, what we have in the provision at 58.5 is that at 58.5, clause 58.5, subsection 5, is that the board must notify them within a reasonable time.
We have a little difficulty.
Mr. Jackson, the Minister, member, let me advise. With technology, currently, we are advising them immediately via email, and we have an online tracking system where they can check, and the system automatically notifies them upon a decision being made.
No, but Mr. Darling, your system advised them of the processing, but when they, suppose there are 5 pieces of documentation, right, that they are obliged to submit for you to assess and determine their application. Upon receiving those 5 pieces of documents requested, how long, is there a statutory period that you must say to them, no, we're not granting you a license?
No, I'll explain to you just the process why that may be difficult. When you apply, we carry out certain investigations on you. Now, depend on the extent of your activities, which may take you wide, we may have to request international reports on you. So that may take some time.
No, reasonable. But Mr. Daly, see this thing about reasonable expectation, if in the normal scheme of things, it should take 2 months. But when you begin to dig, you realize you have to dig deeper and wider. I would want to believe that it would be courteous to say to the applicant after the 2-month period, we are continuing the assessment. However, it will require an extended further period of X amount of weeks or months to complete that. So the person is not left there in a limbo wandering and just like sit at the whim and fancy of the FLA to when they complete it. Just so they know. It's kind of a more customer service approach.
Member, a minute, as the executive has outlined, there's a process now involved, which is we're going digital. Makes life a lot different. So when the application received, it is there. And the next stage is noted. What you'd have to ask, and that will be subject to legislation, is that once the investigation begins, the person be kept informed of the process. And that is really what you'd have to ask. Because legislate, from application to consideration is the limited time. And that is the time that is variable. In terms of consideration, it be immediate. Because once it goes in and they say no or yes, it comes up on their system. The time they will take to receive it, yes, is for them to come in and collect their document, to acquire, to get training, etc. And that's straightforward. It's the variable time is from application until consideration, an investigation. And it's the only request there is that some legislative issues just to inform, keep the system informed on what's happening. So if it looks, if the normal delay, I'll say the normal survey not going to take more than 90 days, but if it have to go for a request to an international part, then that is put on the posting. It's posted on the information. So you can, the CEO, that's a policy issue which should be indicated. I don't think you can legislate that kind of time frame. And I'll ask him to convey, but that's the process we are going towards, which is the digitization is for security in one way, but it's also for customer efficiency. And that's where they're going, and has started to go with the website. Minister, you're asking.
Chairman, I think the issue of time frame is a sore issue generally, and how applications, the timeliness with which matters are processed in government bodies. My understanding is that going forward, if it doesn't currently exist, is that there will be a tracking system where persons, applicants, can know what stage the process is being made. In the past, some timelines are not prescribed because breaching a statutory requirement has its own set of consequences. But increasingly, as part of making government more efficient and responsive, consideration is given to signaling a period within which, after a matter is considered, a decision is communicated. Because otherwise, what you find is that people may use a bribe to clear the way and jump the queue. And then government is yet to develop a reputation of being responsive to people. You know, a lot of government entities are accused of being arrogant and high-handed, and unless somebody knows somebody to find out something from up top, people are not treated with a minimum level of dignity that is required. And I think generally, both administratively and legislatively, something that we have to look at and take seriously in the treatment of persons who are subject to the exercise of the functions carried out by the entities.
Minister, I just want to see.
Mr. Dunn will come in. I think one of the things we have to do in the legislative members is just, and it's good for Mr. Lang to be here to brief you, the narrative versus what's current, and things have been changing rapidly. Once the notification, once the tracking system, which has just started to be operational, therefore there's very little story about it out there. Once the approval is done, it's on the system. The 2 points of variability is the application to the consideration, which we have discussed earlier, and once he gets the notice that he has been approved, then he has to come in and go through a process as well, which it won't take enormously long, but he has to come in, get his documentation that is approved, so he can acquire his firearm, and he has to go and do some training and testing for credibility. That's the time. But the notification now is instant. You know, just as when he comes in, when he go on the machine, it tells you, look, we have an adverse trace. He doesn't have to wait anywhere for anything now. He may want to know what the adverse trace is. That will take some time. So those are immediate activity. And that's where the FLA, more than the organizing government, is going towards digitization, which answers the time frame problem. Right?
Yeah, and I just wanted to add, Minister, that a part of the key performance indicator of the entity and the turnaround time for application is a part of the benchmark of the performance of the entity as well as the staff. So we'll be putting measures in place to ensure that the turnaround time is known to all applicants, and the performance indicator, which is monitored by the Ministry of Finance and the Ministry of National Security, which is the parent ministry, is done as a part of our overall performance and in our annual report to the Parliament.
The object of digitization and general notice is to reduce the contact which offers itself for, let's say, mischief. And that's where they're moving, and the FLA has been moving rapidly in that direction. And then, I know we all agree on that, and I say that, that is what the purpose to do, is to get to a point where certain things are done through that mechanism that prevents the mischief that comes from contact.
We have just another clause to complete this part of the section, this section of the part. 72. And then when we go over, we start another part dealing with the obligations of the whole.
Maybe, Minister, where is it? Where are we now? If it's finished up to 73, you're saying? I want.
Finish.
We are 72.
Minimum clause 72.
Yeah.
At a minimum.
And finish that, right? Yeah. So what I mean, get up to 73, and we can discount the obligation of older family. We can pause there. Very good.
Okay. 71.5. A holder who fails to surrender a license, firearms, or ammunition as required under subsection 4 commits an offense. 72. Amendment of terms and conditions of firearm authorization. 1. The relevant authority may at any time, by notice in writing to the holder of a firearm authorization, vary the terms and conditions of any firearm authorization granted by the relevant authority, other than the prescribed terms and conditions. 2. A notice under subsection 1 shall A. specify the nature of the variation proposed to be made to the terms and conditions, and B. require the holder to deliver the firearm authorization to the authority on or before a day specified in the notice, not being less than 3 days after service of the notice, for the purpose of enabling the variation to be effected. 3. A person who, without lawful excuse, fails to comply with a notice under this section commits an offense. 4. The terms and conditions of a firearm authorization may, on the application of the holder thereof, be varied by the relevant authority if the relevant authority considers it appropriate to do so. And the holder of the firearm authorization shall deliver the firearm authorization to the relevant authority for the purpose of enabling the variation to be effective. 5. Where the terms and conditions of a firearm authorization are varied under this section, the variation shall take effect on the date that, pursuant to subsection 2 or 4, as the case may be, the variation is effected on the authorization.
So we're going to pause here and pick up again at 73 on Tuesday of next week, I think. But just a brief comment for all the members. I didn't say it then, we had a very, what I'd say, vigorous discussion on certain matters, but I want to assure the members, I think it's one of the better features, members of this committee, that we can interrogate issues with a certain intensity and depth with no unnecessary, it's not, I don't see any member seeking to, has any way of undermining the intent of the bill. The truth is, I view most of this discussion, in fact, that this country has a very liberal jurisprudence, which was necessary coming out of the colonial background, but we have to examine circumstances they are today. We are 60-year independent, and there are a number of other issues we raise from time to time. Part of it is as we adapt our jurisprudence to our legislation to the real station that we judge as crucial and a priority now. I don't think I think that kind of debate will always be there as we move towards sometime, in some areas, more conservative legislation. We still have maybe the most liberal human rights charter in this part of the globe. So that's how I view the intense discussion that preceded us. So
you say that as if it's a bad thing.
Eh?
You say it as if it's a bad thing, Mr. Chairman.
No, I'm just saying it is necessary to keep the discussion going, because it's a major piece of legislation with a lot of some level of innovation, and we have to interrogate them thoroughly as we move forward. Let me thank all the members for the participation, for the technical team, which we continue to carry here, but not doing so badly. We are not 72, which is looking like you can see a little light at the end of the tunnel, and it's not the train coming, it's the end of the tunnel. And especially for people, someone like CPC who has been at this in preparation, in drafting, and coming here. Let me thank everybody, and we take our break today until next week, Tuesday, right? 10 o'clock. Thank you.